Good morning, Your Honor. Tracy Thomas appearing on behalf of the plaintiff.
Mr. Smith, can you state your name, please? All right. You guys want to fight with me too?
Absolutely not, Judge.
Hey everybody, the Irish Demon here, back with another video. Now this one I didn't actually see. I did, however, listen to it on the way in the car from Dublin back to Cork. I don't know what's in the air lately, but lawyers arguing with judges and kind of talking over them in a snippy way seems to be all the rage right now. So anyway, I'm going to play this video for you. Let me know what you think and we'll catch you at the end.
Good morning, Your Honor. Kevin Callahan for plaintiff, P78273. I have with me the owner of the property, Abreet Kaur.
Good morning, Your Honor. Robert.
Go ahead.
I'm sorry, Your Honor. Good morning, Robert Beal here, Your Honor.
All right. Counsel, did you receive a copy of the answer?
We received a copy of the answer by email at 4:36 last night. It's my understanding from our last court date that Mr. Beal indicated that he was having his lawyer appear. No lawyer has appeared on the case. He was required to tender $10,000 into the court's escrow by the 10th of July. I don't have evidence of that. Not to say that it didn't happen. I don't have evidence of it. And he was required to answer the complaint by the 10th of July. And we just received the answer last night that poses zero legal defenses, Judge.
Mr. Beal, do you have an attorney here?
No, Steve Wallace will be hired as of next week. The reason I did not put the escrow in Monday as you required me to and give the answer, my business partner had a stroke in Oregon. I flew to Oregon and I just got back Thursday night. And my wife has already took the funds out the account. I didn't want her to take that a lot of money up there by herself. So I told her I'd start working on that after I speak with you today. But we have all of the rent money.
That escrow was supposed to be in.
Yes, Your Honor, you're right.
Oh, I know. And all right. And the answer was supposed to be in earlier than it is now. And I don't see where you're indicating that any defenses to the amount they're claiming is owed.
The amount they're claiming is owed, we're off a few $1,000s, but not the majority of the rent. The majority of the rent, or the $4,500, is definitely due. I have been going back and forth with the management company to do some things around the house, and they have yet to do everything. But the key thing was the deck and the security of the deck. They told me we were going to put a deck up. They decided not to. I asked them to let me pay for the deck. Let me pay for the deck. They said, well, you pay for it. We're not going to reimburse you for it. I said, well, what about if I sell it to you back at 30% after I leave, after the lease is up? They said, no. I said, well, if I pay for the deck, can I take it with me when I leave? They said no. So I have been trying back and forth to go back and forth with them to try to work out an agreement with the deck. I did speak with the county yesterday, Steve, the inspector, and he said by law, they're not required to put a deck up, but they are required to have a security barrier back there. So Steve said he was going to call, Steve, the inspector for the county, said he was going to call email the owner to see if they can arrange to put a barrier up. Once that barrier is up, I'm fine. I don't have a problem.
How much is owing on this account?
With court cost, Judge, it's $18,944.23. Court costs are $235.
Here's what I'm going to do in this case is I'm going to, the escrow needs to be paid. Mr. Beal, we've been through this before. You always make promises to me in another case. You always make all these promises. There's some excuse, and you're just going to have to put up or not. I mean, I ordered $10,000 in escrow. You said you were going to pay it. I get here today. You didn't do it. I don't have any proof of what are the other things that you're talking about. Don't need it, quite frankly. You were supposed to put the $10,000 into escrow. So, if the escrow is, so I will grant the judgment. If the escrow is paid, then the judgment will not enter. It needs to be paid today. If the escrow is paid today by close of business, then this matter adjourns out to July 21st, 2023 at what time? At 10 a.m. So the escrow needs to get there. If it's not here today, plaintiff's entitled to their judgment for their full amount. If it's there today, then I'll see you guys next week at 10.
Judge, if I may,
I make my orders, you got to follow.
Judge, if I may
Understood.
respond,
Pardon?
if I may respond to that, Judge.
Sure.
Judge, there's absolutely zero reason for us to adjourn this again. Mr. Beal, at our second court date,
Counsel.
if I could,
That is what I'm doing. I don't need a response from you. That is what I'm doing.
Judge, I would like to make a record if I could.
I go for it.
Thank you, Judge. At the second court date, we received a possession judgment for the full amount. Mr. Beal was not present. Mr. Beal decided to come later on, and the court set aside that judgment. At the subsequent hearing, Mr. Beal made promises to this court, made promises to us that he has a lawyer, he has the escrow, he has this, he has that. He didn't do anything he was required to, and there's zero legal defenses here. I don't understand why we are adjourning it again when there's absolutely zero legal defenses. If Mr. Beal has some kind of misunderstanding about,
are you done? Are you done?
I'm not done. No, Judge. I'm trying to make my
hurry
argument
up.
for the record.
Get done.
Thank you, Judge.
Get done.
Thank you, Judge. Any dispute about a deck is between the owner and the city and has nothing to do with the legal contract and has nothing to do with Mr. Beal's obligation to tender rent. I have an owner here that has been displaced from her house. She's owed over $18,000 and is not receiving a single dime here. I don't know why you're giving Mr. Beal another opportunity when there's absolutely zero legal defenses.
All right. First of all, part of your record is wrong. And absolutely wrong, because that was explained to you the last time. So don't try to distort the record, counsel. The reason that the judgment was set aside is Mr. Beal was attempting to try to get in. We verified it. In deference to somebody trying to sign into Zoom, I set aside the judgment. I explained that to you. So don't try to distort what happened. Second thing, I told Mr. Beal this is what he needed to do. He has given me some reason why he did not do it. Certainly, I question whether or not all of that occurred. But what I did is I said, look, if you were to put the escrow in, he files the answer, we'd have to deal with that anyway. He's saying there's a reason why he didn't put the escrow in. I'm giving him till today to get the escrow in. If the escrow's not in, you get your judgment. It's as simple as that. That's why that's happening. I'm done. Case over. We'll see you next week or not.
Now, I think that much like a lot of the people appearing in these courts, because it's on Zoom, they seem to get a little bit braver. I wonder if it's the same with lawyers. Now, I have seen lawyers in real life get snippy with judges before, but it seems to be getting more and more common now. In fact, I'm going to upload a video later of a lawyer getting really snippy with a judge. The judge puts him right in his place. Anyway, lads and lassies, if you enjoyed this video, make sure and give it a thumbs up, and we'll catch you in the next one. Sláinte.